Before we start, I would just like to begin by acknowledging the Awabakal people, traditional custodians of the land on which we meet today, and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples that may be here today. So my name's Kim Richardson, and I'm a solicitor at the Hunter Community Legal Centre. We provide free legal advice to people who live, work, or study within the Hunter region. It's important to note that the information provided in this session today is only for information purposes. It must not be relied upon as legal advice. If you have a legal issue, you should seek individual legal advice about your particular set of circumstances. Okay, so today's talk is going to be on renting and tenancy. Okay, so I'm not sure if you're tenants or not, but you may be familiar with a residential tenancy and a lease that you would generally sign when you enter into a residential tenancy. There are different types of terms which form part of a residential tenancy. The terms of the standard agreement, so the Residential Tenancies Act, says that landlords must use the standard terms that are set out in the Residential Tenancies Regulation 2019. The terms of the standard residential tenancy agreement cannot be varied. If you do not carry out the responsibilities that are set out in the residential tenancies regulation, you can be said to have breached that term of the agreement. There are also, it's important to note that there are some prohibited terms that cannot be included in a residential tenancy agreement. Section 19(2) of the Residential Tenancies Act says that terms have the following effects must not be included in a residential tenancy agreement. One, that the tenant must have the carpet professionally cleaned or pay the cost of such cleaning at the end of a tenancy, unless it's required because there have been animals kept on the premises during the tenancy. That the tenant must take out a specified or any type of insurance, exempting the landlord from liability for any act or omission by the landlord's agent, or any person acting on behalf of the landlord. That if the tenant breaches the agreement, the tenant is liable to pay all or any part of the remaining rent under the agreement, increased rent, a penalty, or liquidated damages. And that if the tenant does not breach the agreement, the rent is or may be reduced, or the tenant may or is to be paid a rebate of the rent or other benefit. So probably the most important prohibited term that is most relevant, I would think, would be that if you're a tenant, even if your residential tenancy agreement says that you must get the carpet professionally cleaned, that is a prohibited term. So unless you have had a pet in the house whilst you've been a tenant, you don't need to worry about having the carpet professionally cleaned or paying that cost. If there are inconsistent or prohibited terms, they're void. So a term is void if it is inconsistent with any term of the standard residential tenancy agreement or prohibited by the Act or regulations. Now, additional terms may be included in the standard residential tenancy agreement if both yourself and the landlord agree to them. They don't conflict with the Residential Tenancies Act or any other legislation, and they do not conflict with the terms of the standard agreement. So it's not possible for an additional term to override anything that is set out in the standard agreement of your residential tenancy agreement. Okay. So who is and who is not covered by the Act? So the Residential Tenancy Act covers private tenants who have a written or oral tenancy agreement, social housing tenants, including tenants of Department of Communities and Justice Housing, community housing providers, and the Aboriginal Housing Office. Social housing providers have certain specific rights and obligations under the Act in addition to an ordinary tenancy agreement. The Act also covers people who rent a home in a land lease community. Now, the Act does not cover people who own a home and rent a site in a land lease community. They are covered by a different legislation, and that's called the Residential Land Lease Communities Act. Protected tenants are also not covered, and they're tenants who are living in premises that are covered by the former Landlord and Tenant Amendment Act of 1948, residential aged care or respite care services, serviced apartments, hotels, motels, and backpacker hostels, hospitals and nursing homes, club premises used to provide temporary accommodation, premises used mostly for the purpose of trade, profession, business, or agriculture. Holiday parks, occupation agreements are also not covered. Retirement village residence contracts, refugee or crisis accommodation agreements. Borders and lodges are not covered as well. And agreements giving the right to occupy a residential premises for no more than 3 months for a holiday are also not covered by the Residential Tenancies Act. It's important to note that the Act also does not apply where a tenant has made an agreement in good faith for the sale, purchase, or mortgage of the residential premises, where a tenant is a shareholder living in company title premises, where a tenancy agreement is part of an equity purchase agreement, which gives the tenant an option to buy, and to most family arrangements. Okay, there are a number of costs that are payable at the start of a tenancy. It's important to note that a landlord or an agent can only ask you to pay a holding fee, rent, a bond, or any other costs that are prescribed by the legislation. If you are asked to pay any money, it's important that you get a detailed receipt for any payments that you make. This is for your own protection so that you are able to prove what you have actually paid to the landlord or the agent. If you need help in paying any of these expenses, there are a couple of services that do provide assistance. So the Rent Start Loan Scheme helps disadvantaged tenants in the private rental market with money for bond and rent in advance. If you are wanting to make an application, you need to make an application through the Department of Community and Justice Housing. In relation to holding fees, a landlord or an agent may ask you to pay a holding fee on approval of your application for a tenancy. And the most that they can ask as a holding fee is 1 week's rent. The landlord or agent can only hold one holding fee at a time. So they're not able to take the holding fees from several people at once. On receiving the holding fee, the landlord or agent can't enter into an agreement with another prospective tenant for 7 days or longer if you both agree. So what that would mean is that if you pay a holding fee, the landlord or agent would not be able to rent that property for at least 7 days to another party. And upon signing the tenancy agreement, that holding fee that has been paid goes towards the rent from the first day of your tenancy. So it's not money that you just pay out and then you lose. It's money that would then get counted towards your rent. The landlord or agent must refund the holding fee if they end up declining to enter into a residential tenancy agreement, or you refuse to enter into the tenancy agreement because the landlord or the agent has made some false or misleading statements to you, or they failed to tell you any material facts. If you otherwise decide not to enter into the tenancy agreement, the landlord or agent can keep the fee. So that's really important to note, that if you are asked to pay a holding fee, there are only certain circumstances in which that money can be refunded if you change your mind and you decide that you no longer want to proceed with that tenancy. In terms of paying rent in advance, a landlord or agent cannot require you to pay more than 2 weeks' rent in advance. You can choose to pay more, but you can't be asked to pay more. Now, the landlord or agent can then not demand further rent until it falls due, and cannot ask for a post-dated check either. Now, electricity, gas, and telecommunication charges are payable by the tenant to the relevant authorities. So that's a cost that you would also have to factor in when you are looking at entering into a tenancy agreement. Okay, now with the bond, this is security in case the tenancy agreement is not offered, either by the landlord or the tenant. Now, the bond can be paid as a lump sum, or it can also be paid in installments, starting from when you sign the tenancy agreement, provided that the landlord agrees to that, of course. When you pay the bond, the landlord or the agent must give you a receipt for any payments that you make, unless the details of the payment are recorded on your tenancy agreement, as well as a bond lodgement form with details about how much bond you have paid, and this will be sent off with the bond. You and the landlord should also sign the bond lodgement form. And again, if you need any help in paying the bond, the Rent Start scheme, there is a scheme, it's the Rent Start scheme, offers assistance to people with low incomes in renting. And again, you would apply through Department of Communities and Justice Housing Office. The landlord or the agent must deposit the bond with New South Wales Fair Trading. For lump sum payments, the landlord must deposit the bond within 10 working days of it being paid. Now, if you're paying that by installments, the agent must deposit it within 10 days of the end of the month. Once the landlord or the agent has deposited the bond, Fair Trading will send you a deposit notice and a rental bond number. You should make sure that you keep these in a safe place with your tenancy agreement. If you do not receive a bond notice, you should contact Fair Trading to find out if the landlord or the agent has deposited the bond. If the landlord or the agent does not deposit the bond within the required period, they can actually be fined up to $2,200. At the end of the tenancy, you can actually fill in a claim for refund of bond money form from New South Wales Fair Trading. If you and the landlord and the agent agree about the amount to be returned, you can sign the completed form and have the landlord and agent sign it, and then return that back to Fair Trading by post or email or in person. Fair Trading would then deposit the bond money into your bank account or post out a check to your new address. Now, you can still make a claim for the return of your bond, even if you disagree about the amount of bond to be returned. And I'm sure that a lot of people aren't aware that they can actually make the claim for the return of their bond, where the landlord or the agent might be saying, well, you owe us money because, the oven's not clean, or for some other reason that they've given you. The process is the same. You fill in the form with the amount that you want paid to you. You don't need to get the landlord or the agent's signature. You just send the form back to Fair Trading. Fair Trading will give the landlord or the agent written notice that you have made a claim. And if the landlord or agent doesn't dispute it, then Fair Trading will simply return the money to you after 14 days. If the landlord or the agent does dispute your claim, They have to then make an application to the New South Wales Civil and Administrative Tribunal, which is known as NCAT for short, within 14 days of receiving the notice, and tell Fair Trading in writing that they have done so. NCAT would then decide how the bond would be paid out, and you would have the opportunity to respond to that application. To the application by the landlord or the agent. Now, if the landlord or the agent wants to make a claim for the bond without your agreement, they must give you a copy of the condition report that was completed at the end of the tenancy agreement, copies of estimates, quotes, invoices, or receipts for work they are claiming, and they must provide these to you within 7 days of making the claim. Fair Trading will then give you written notice that the landlord or the agent has made the claim. And then if you dispute that claim, you then have to make an application to NCAT for an order to pay out all or part of the bond to you within 14 days. So that's the same requirement for a tenant as it is for a landlord if there is a dispute about payment of the bond. Now, the landlord or the agent may claim from the bond the reasonable cost of repairs. So, for example, if you or another occupant or a guest has damaged the premises or goods that may have been leased with the premises, other than fair wear and tear, cleaning. So, if you have not left any part of the premises not reasonably clean, replacing locks or other security devices if you have altered, removed, or added these without the landlord's consent. They can also make the claim if you owe rent or any other charges that may be payable under the tenancy agreement. Now, share housing is a little different. So renters in share housing are generally covered by the Residential Tenancies Act 2010 and the Residential Tenancies Regulation 2019. People in share housing will usually have their own bedroom and share the rest of the premises. Your rights and obligations will depend on your legal status. You may be a co-tenant, a head tenant, a subtenant, or you could even be a boarder or a lodger. Co-tenants, head tenants, and subtenants all have rights and obligations under the Residential Tenancies Act. Boarders and lodgers do not. If you are a co-tenant, your name and the names of other tenants are on the tenancy agreement for the premises. You share rights and obligations with the other co-tenants. You're a head tenant, so that means your name is on the tenancy agreement for the premises. You live at the premises and you sublet part of the premises to another person under a separate written agreement, and that person is a subtenant. In this case, it's a landlord-tenant situation. So the head tenant would in fact be the landlord for the subtenant. And the subtenant, so you're sharing with a tenant who has sublet part of the premises to you under a separate agreement. And you have the rights and obligations of a tenant in relation to the head tenant. And so they're your landlord. Now, as I said, boarders and lodgers are not covered under the Residential Tenancies Act. You would be a boarder or a lodger if you rent part of the premises from a tenant who also lives there, or the owner of the premises who also lives there, and they keep control over the whole premises, including the part that you rent, and they are your landlord. Boarders and lodgers fall into an area that is called marginal renters. Now, they are renters who pay for the right to occupy residential premises, but who are not covered by the Residential Tenancies Act. Whether you are a boarder or a lodger or a tenant will depend on how much control the landlord or the live-in manager or caretaker, as the case might be, has over the premises. You are likely to be a tenant rather than a boarder or a lodger if you have exclusive access to your own room, so no one else can use your room and you can actually lock it. You don't get meals, linen, or cleaning as part of your agreement. You have your own cooking facilities. There are no house rules that can be enforced. If there is any question about whether or not you might be a tenant or a boarder or a lodger, the New South Wales Civil and Administrative Tribunal can actually make a determination and decide whether a person might be a tenant or whether in fact they're actually a boarder or a lodger. Now, if you're a boarder or a lodger and your landlord evicts you, you can challenge this in the tribunal in certain circumstances. And if you have any questions about whether or not you may be a boarder or a lodger, you should certainly get some legal advice if there are any issues in relation to your tenancy. Now, in relation to occupancy for a boarding house, there are a number of requirements that occupancy rights has to include, and that includes clean and secure accommodation, the quiet enjoyment, notice of rent increases and evictions, and access to recover goods after the end of the occupancy. It's important to ask for receipts when you pay rent. If the landlord will not give you any receipts, you should keep a record such as a diary of cash payments, or you should pay by a check or a money order and keep the stubs safe and secure so that if there's any doubt in the future about the amount of money that you may have paid in rent, you can actually prove that. Now, if you pay a bond, be sure that you get a receipt. You should encourage the landlord to deposit the bond money with New South Wales Fair Trading. However, unlike a landlord under a residential tenancies agreement, they are not required to by law. If you're wanting to leave, you need to give the landlord a written notice to leave according to the agreement that you have between the two of you. And you should also keep a copy of your notice. If your agreement does not have a notice period, you need to give what's called reasonable notice. So, for example, if you pay rent weekly, you should be looking to give 7 days notice of wanting to leave. And it's important that when you do leave, that you take all of your belongings with you. If not, it can be very difficult to get them back. Now, if the landlord is wanting to evict you, the landlord also has to give you reasonable notice. If there are any disputes with your landlord, it will largely depend on the type of agreement that you have as to how that dispute can get resolved. If you rent a room in a registrable boarding house, you may have access to dispute resolution through the Boarding Houses Act 2012. If your landlord is running a business, so for example, you're renting a room in a hostel, you may actually be able to apply under the Fair Trading Act to the General Division of NCAT to have your dispute heard. If your landlord is not carrying on a business, so you simply just rent a room in your landlord's house, only the courts can deal with your dispute. And in most cases, you would have to apply to the local court. And that's a very important difference between a residential tenant and someone who is a boarder or a lodger. A residential tenant can have their disputes and issues solved in NCAT, whereas a boarder or a lodger actually has to take the step to take action in the local court. So if you're a tenant, it is possible that you may be renting a unit that is subject to strata legislation. Strata law is a very complex area of law, but just briefly, within a strata scheme, there is the owner's corporation. The owner's corporation previously was called a body corporate, is the name for all the individual owners of the units in a strata title building. Now, the owner's corporation makes decisions about the management of the whole building at meetings which are held regularly throughout the year. Bylaws are the rules for managing the strata scheme. They are registered with New South Wales Land Registry Services. The landlord or the agent must give you a copy of the Owners Corporation bylaws within 7 days of entering into the tenancy with you. So for examples of bylaws, so no pets on the premises, no access to the rooftop after 10 p.m, no bicycles to be chained to the stairwell, or floors to have some form of carpet or floor covering. Some owners' corporations make house rules, which they also expect occupants to follow. However, if such rules are not registered as bylaws, they are not lawful and you are not bound to follow them. Under the Strata Schemes Management Act 2015, the Owners Corporation can serve notices on owners or tenants to comply with bylaws. And if the notice to comply is not followed, the Owners Corporation can apply for an order from NCAT for a fine of up to $1,100 to be paid by the owner or the tenant. Bylaws are also terms of your agreement with your landlord, and breaches of bylaws can be treated by your landlord as breaches of your agreement. So if you are renting in a strata titled property, it's important to make sure that you have firstly been given a copy of the bylaws and that you're not in breach of those bylaws, because that will put you in breach of your residential tenancy agreement and your landlord would be able to take action against you for that. Now, from the 23rd of March 2020, there was some new legislation brought in relation to strata schemes, and your landlord or the agent must provide you with a copy of the bylaws before you actually enter into the agreement. So if you entered into the residential tenancy agreement prior to the 23rd of March 2020, your landlord or the agent had 7 days from after you entered into the agreement to give you a copy of the bylaws. Now they must give that to you as soon as you enter, or before you enter, into the residential tenancy agreement. And this new disclosure has been made so that a tenant can be better informed about the bylaws that will apply and make a decision about whether or not you actually want to take up the tenancy. Your landlord or the agent must also inform you if a strata renewal committee has been established, which is usually formed to consider selling or redeveloping the strata scheme. If your landlord or the agent has failed to disclose these facts to you, they can be fined up to $2,200. And in some cases, it might also allow the tenant the opportunity to end the tenancy. Now, where there are disputes, the Strata Scheme Management Act sets out a process for resolving disputes between occupants of strata schemes and the owners corporation. The first step is mediation. If speaking or writing to each other does not resolve the dispute, you can then apply to the NCAT for mediation. Now, it's important to note that this process of applying for mediation to NCAT is required for most disputes. So if speaking or writing isn't resolving the issue, then it's necessary to make that NCAT application. You can get the application for mediation from New South Wales Fair Trading, and it's available on their website. It's also free, so that's a bonus. You can also try the Community Justice Centre, where mediation is also free. An attempt at mediation is required before some disputes can go to NCAT. If mediation is not successful, that's where the next step would be to make an application to NCAT. NCAT can hear certain applications by tenants against the Owners Corporation or also other occupants of the strata scheme. There is a fee involved in making the application, and it's $101, although if you're a full-time student or a pensioner, the cost is only $25. Now, one of the big issues about a strata scheme is the keeping of pets. Some tenancy agreements have an additional term that says you must have the landlord's consent before you can keep a pet. In strata schemes, some bylaws state that you also need the written consent of the owner's corporation before you can actually get a pet. If your landlord has agreed to you keeping a pet, but the bylaw prohibits the keeping of the pets, you should ask your landlord to challenge the bylaw. It's important to note, however, that even if you have the consent of your landlord and the owner's corporation, any other occupier can also apply for an order to remove the pet on the grounds that it's causing a nuisance. So if you get permission from your landlord and also the owner's corporation to have a dog, and the dog barks a lot when you're not at home, for example, another person who is living in that strata scheme can actually seek an order for your pet to be removed on the grounds that it's barking and being a nuisance. However, if you have a guide dog or a hearing dog, there is no bylaws that can prevent you from having those dogs live with you. If the strata scheme has changed or is proposing to charge a pet license fee or something similar, this is unlawful and you should make a complaint to New South Wales Fair Trading. And an owner's corporation cannot actually evict a tenant from the property. Okay. Before signing a residential tenancy agreement, they must not knowingly hide any of these material facts from you. Now, the landlord must not knowingly conceal whether or not the premises have been subject to serious flooding or bushfire in the last 5 years. The premises have significant health or safety risks that are not apparent on an inspection. The premises have been the scene of a serious violent crime in the past 5 years. Council waste services will be different from an ordinary council waste service, that you cannot get a free residential parking permit in an area where there's only paid parking available. The premises have a driveway or a walkway that others can legally use. The premises was the scene of a drug offence within the last 2 years. The premises is listed on the loose fill asbestos insulation register that's maintained under the Home Building Act. If you are renting in a strata scheme, any scheduled repairs to common property during your fixed term, and if your premises is in a building where a rectification of the building's external combustible cladding is required, the landlord or the agent must tell you if any of the following have been issued in relation to this: fire safety orders or notice of intention to issue a fire safety order, a building rectification order, or notice of intention to issue a building rectification order, a development application or complying development certificate application for rectification of the building. The landlord or the agent, if the agent is aware, must also tell you if either of the following apply. They propose to sell the premises, or a mortgagee, so their bank, has started court proceedings to enforce the mortgage over the premises. So it might be a situation where the landlord has failed to pay the mortgage and their bank is taking action to get possession of the house. In all of these circumstances, if the landlord has failed to provide this information to you or disclose it to you, you can actually terminate your tenancy. Now, there are a number of standard tenant rights that that a tenant has under the Residential Tenancies Act. You have a right to be given a copy of the residential tenancy agreement, a condition report completed by the landlord or the agent, and a copy of the New South Wales Fair Trading New Tenant Checklist. To have premises rented to you in a reasonable state of cleanliness and fit to live in. To be given rent receipts unless you pay rent into a nominated bank account. To be offered at least one means of paying the rent for which you do not incur a cost. that there are no rent increases no more than once every 12 months during a continuing lease, to be given 60 days written notice of a rent increase, to have quiet enjoyment and use of the premises, so the landlord or the agent must not interfere with your possession of the premises, to have reasonable peace, comfort, and privacy, to have reasonable locks and security, and to have reasonable repairs and maintenance done, to be given permission to make changes of a minor nature, so putting up new curtains or child safety measures, to be repaid for any urgent repairs that you have had to pay up to an amount of $1,000. So if the hot water service breaks on a Saturday night, to be able to, have a plumber come out and fix that and then recover that money from the landlord at a later date. To apply to NCAT for orders if the landlord has broken the tenancy agreement. To be given written notice of the landlord wanting to end the tenancy agreement. To be notified of the change of name and address of the landlord or their agent. To refuse the landlord access except in certain circumstances and with proper notice, and not to be unlawfully evicted. So here again is just a list again of the standard tenant rights. So these are the things that you are entitled to have as a tenant. Now, as a tenant, you also have a number of obligations under the Residential Tenancies Agreement. One is that you need to fill out the condition report and to give the landlord or agent a copy within 7 days. In my opinion, this is a very important step that a lot of tenants do miss when they are renting a property from a landlord or an agent. It's easy to overlook or to think, I'll just do it later. But if at a later stage there is an issue that arises about the condition of the property at the start of the tenancy, the condition report that you have filled out will be very important. So it's very important to make sure that you fill out the condition report as soon as you can and to give the landlord and agent a copy. Now, I would also recommend that you take photographs of the condition of each room when you move into the property and to store those photographs somewhere safe. It may even pay to print them out so that they're not just going to get lost in the cloud or you forget about them when it's 12 months later and you're moving out. Another standard tenant obligation is to pay your rent on time, to pay water usage and utility charges such as electricity, gas on time. And if the premises are separately metered and have prescribed water efficiency measures installed, you also have an obligation as a tenant to care for the premises, to pay for any damage caused by you or your guests, to report the need for any repairs or maintenance, not to make alterations or additions without the landlord's permission, and the landlord must not unreasonably withhold consent for changes that are a minor nature, not to alter, remove, or add a lock or security device without the landlord's consent, except in certain domestic violence situations, not to use or permit the premises to be used for an illegal purpose, not to cause or permit a nuisance, not to interfere with the peace, comfort, or privacy of your neighbours, to give the correct written notice when you leave, and to leave the premises in a similar condition to when you rented them, except for normal fair wear and tear. Okay, now there are some circumstances where a landlord does have the right to enter the premises. Now, they can enter the premises with consent. So the landlord or the agent or some other person that's been authorised by the landlord, such as a repair person, for example, can enter the premises at any time, provided that the tenant consents to that. If a tenant is not consenting, then the landlord has to give proper notice. So the landlord or the agent, or another person, again authorised by the landlord, can only enter the premises without your consent and without notice, only in an emergency or to do urgent repairs, or if the landlord thinks that the premises have been abandoned, or in accordance with an order from NCAT, or if they have serious concerns about the health or safety of a person on the premises after they've first tried to get your consent to enter. Now, where there is no consent and they've provided you with notice, they can enter the premises without your consent, provided that they've given you notice. Now, the notice does not have to be in writing. That's important to note, because some tenants think that all notices need to be in writing, but they don't necessarily have to be. And if the notice is posted to you, the landlord or the agent must allow an extra 7 working days for delivery. So if the landlord or the agent were proposing to enter your house on a particular date, and they posted that letter out or that notice out to you, they would have to allow 7 days for you to receive that notice, and then 7 days notice requirements. Now, a landlord or an agent can access your premises to take photos or a visual recording of your interior of your rented premises for advertising purposes without your consent, although they must first give you reasonable notice and an opportunity to move your possessions out of the frame. However, the landlord must obtain your written consent to publish these photos or visual recording publicly, such as on a website, a flyer, a newspaper, or other publication, if they visibly show your possessions. You can't unreasonably withhold your consent to such a publication, but there are circumstances where you could reasonably withhold that consent, such as if you've been in a circumstance of domestic violence, then that would consider to be a reasonable and valid reason to withhold consent for photographs of your possessions to be published. Now, if the property is listed for sale or for lease, a landlord or the agent is able to show the premises to prospective tenants, but they must give reasonable notice and a reasonable number of times. Unfortunately, in this case, the law doesn't say what reasonable means, and there are often disagreements about what reasonable is. If there are disagreements about what is reasonable, then you can make an application to NCAT. In those circumstances where you're looking at making an application to NCAT, you can do that for an order to specify or limit the days and times on which the landlord or the agent can show the premises. And similarly, if you refuse access, the landlord or agent can also apply to NCAT for an order that authorises them to show the property or enter the premises. Now, the landlord or the agent or any other person that's authorised by the landlord must not enter before 8 a.m. or after 8 p.m, enter on a Sunday or a public holiday, stay longer than necessary. They must, if they can, notify you of the proposed time and date of entry. A person authorised by the landlord or the agent must have written consent from the landlord or the agent to enter the premises. If you are at home when this person arrives, they have to show you the consent. So if there is someone who has turned up and said that I'm from the landlord has sent me, or the agent has sent me, I'm here to do X, Y, Z, you can actually require them to show you the written consent. If you're not at home, you can try and arrange for someone else to be there on your behalf. And people entering the premises when you are not there may be a problem for your insurance if you do have any insurance. So you should check with your insurance company about this. If your goods are stolen or damaged, you can make an application to NCAT for compensation. Now, you have to be able to show that your loss was due to the conduct of the landlord or the agent or the other authorized person. There are a number of ways that a residential tenancy agreement can be terminated. So you can end your tenancy without a reason or for a legally specified reason. In most cases, if you're a tenant and you're terminating the tenancy, you have to give the landlord or the agent a written termination notice and vacate, so move out and return the keys according to your notice. You can vacate before the date in your termination notice, but you would need to keep paying rent until the end of the notice period. In some cases, you can apply to NCAT for a termination order. If the tribunal makes the order, it will end your tenancy and specify the day by which you must vacate. A termination notice must be in writing, signed by you, and say the address of the premises, the day on which you will vacate, and the reason, if there is one. You must properly send or deliver the notice to the landlord or the agent. You can do that in person, by post, or by email. If there is an email address specified in the residential tenancy agreement or by the agent for documents of that kind, or by hand to a mailbox at the landlord or agent's home or business address. For a fixed term agreement, you need to give at least 14 days notice. The termination date in the notice can be the last day of the fixed term or up to 14 days after. You have to give this notice before your fixed term agreement ends. And you need to vacate by the date on your notice. That is very important. If you have a fixed term agreement and you are wanting to end the agreement at the end of the fixed term agreement, then you need to give that 14-day notice. If you're on a periodic agreement, you need to give a minimum 21-day termination notice. And again, vacate by the date in your notice. Now, where there is a co-tenancy, it's a little different. If all co-tenants are leaving, all must jointly give the landlord a termination notice, 21 days for a periodic agreement, or again, 14 days for the end of a fixed term agreement. If one co-tenant is leaving during a periodic agreement, they just need to give 21-day termination notice to the landlord and to every other co-tenant. And once they vacate by the date in their notice, they will no longer be a tenant under the agreement. During a fixed term agreement, a co-tenant can try applying for a termination order to end their own tenancy in special circumstances or transfer their tenancy to another person. And the landlord also has they also have grounds and reasons that are set out in the residential tenancy agreement, and they also have to provide a written notice of termination. Discrimination. Okay. Discrimination essentially means treating someone unfairly because they belong to a particular group of people. Unlawful discrimination can take many forms, including harassing or treating people unfairly on the basis of their race, sex, gender identity, sexuality, disability, marital status, or age. Now, sexual harassment is where a person makes unwelcome sexual advances or requests to another or unwelcome conduct of a sexual nature in a situation where such behavior is likely to intimidate, humiliate, or offend. It is against the law to discriminate against people for any of the above reasons. But only, yes, it's against the law to discriminate against people for any of the above reasons. But there, so it's unlawful for a landlord or real estate agent to discriminate against you when rental accommodation is advertised. So, for example, an ad says that people of a particular ethnic group cannot apply. When you inquire about the availability of advertised accommodation, and for example, an agent refuses to show you a vacant rental property to two unmarried women. When you apply for rental accommodation, that the landlord or the agent might refuse to take your application or placing you lower on the list of applicants. While you are renting accommodation by imposing terms or conditions that are discriminatory, for example, trying to limit the number of people that you can invite to visit. By ending the tenancy because of your race or sex, gender identity, sexuality, disability, marital status, or age, by sexually harassing you in the course of you being provided or offered accommodation, or by not giving you all the benefits associated with your accommodation. For example, if you live in flats with a pool and you're not able to use the pool because you have a child with a disability. There are some exceptions to this, and this relates to shared accommodation. Whether it is unlawful to discriminate in shared accommodation depends on the type of discrimination and whether you are living with the owner or their close relative and how many people you are sharing with. Under the Racial Discrimination Act, an act is not unlawful in relation to accommodation if sharing with the owner or their close relative. Under the Sex Discrimination Act and the Disability Discrimination Act, an act is not unlawful in relation to accommodation if, again, you are sharing with the owner or their close relative, and if it's for no more than 3 people. Under the Anti-Discrimination Act, an act is not unlawful if, again, the tenant is sharing with the owner or their close relative, and if the accommodation is for no more than 6 people. It may not be unlawful to discriminate if the accommodation is designed to meet the needs of a particular group, such as women or older persons or young people. And if you're faced a situation like that, we would recommend that you get specific legal advice in relation to your rights. If you believe that you have been discriminated against, you can make a complaint to the Anti-Discrimination Board of New South Wales or the Australian Human Rights Commission. If you are wanting to make a complaint to either of those bodies, you have 12 months to lodge a complaint with the Anti-Discrimination Board and 6 months for the Australian Human Rights Commission. Now, tenancy law can actually help in situations of domestic violence. In circumstances of domestic violence, New South Wales tenancy law provides some help to victim survivors and other innocent parties. Now, this will depend on a number of things. So whether your agreement is fixed term, so for example, if it's for 6 months, or if it's an ongoing agreement. Your tenancy status, so whether or not you're a head tenant, a subtenant, a co-tenant. The tenancy status of the perpetrator, whether or not you want to leave or stay, whether or not you want the perpetrator to leave, whether you have an apprehended violence order, what sort of apprehended violence order you have, whether or not it's an interim order, a provisional order, a final order, and whether or not any of those orders excludes the perpetrator. Whether you have any other documentary evidence of domestic violence, and the help that is available could be one or more of the following. It might be ending the perpetrator's tenancy, ending your tenancy, transferring your tenancy, protecting the victim survivor from breach fees and costs for property damage in some circumstances. A landlord or agent will not be allowed to list information about a tenant in a tenancy database when the tenant has terminated the agreement in circumstances of domestic violence. To access these rights, you may need to make an application to NCAT, and you may also need to give a termination notice. Now, you can apply for an AVO. So the AVO would prevent a person from doing certain things so as to ensure the safety and protection of another person. An AVO in itself is a court order. They do not mean that a crime has been committed, but breaching an AVO is a crime. An AVO can either be personal or domestic. So if it's a personal order, you may see it called an apprehended personal violence order, or if it's a domestic order, it might be referred to as an apprehended domestic violence order. Most AVOs are applied for by the police in domestic situations. However, in some cases, it may be necessary for the victim survivor to make that application themselves. In tenancy law, it can matter whether or not the AVO is final, interim, or provisional, whether it excludes the perpetrator from the rented premises by address, and whether or not it's an APVO or an ADVO, so whether or not it's a personal violence order or a domestic violence order. Now, ordinarily, tenants cannot change the locks without the prior consent of the landlord or without a reasonable excuse. A tenant or occupant being prohibited from entering by an AVO is a reasonable excuse. So if there is an AVO in place that prohibits the perpetrator from going to the house, you are able to change the locks. If you change the locks, you need to provide a copy of the keys to the landlord within 7 days, unless the AVO is against the landlord. Now, with the bond, the NCAT can actually make orders of bond payment between co-tenants if one co-tenant's tenancy has ended. So, for example, if you have left, you can make a written demand of your former co-tenant for payment of your share of the bond. You must give the co-tenant 14 days in which to pay. And if they do not pay, you can then apply to the tribunal within 28 days of the end of the 14-day period. Subtenants covered by the Residential Tenancies Act can also apply to NCAT for bond orders against their head tenant. Where goods have been left at the premises, NCAT can make orders for the remaining co-tenant to hand over goods left behind by a departed former co-tenant. And this application to NCAT must be made within 28 days of leaving. All right, you've heard a lot about NCAT throughout this presentation. So NCAT, so the New South Wales Civil and Administrative Tribunal, is an independent body which deals with certain kinds of disputes between landlords and tenants. It is not a formal court, but its decisions are legally binding. The people who hear cases at NCAT are called tribunal members. And if you ever appear in front of NCAT, you can just call them tribunal member. Most remedies from NCAT are for breach of contract, so not obeying the terms of the residential tenancy agreement. NCAT was established in January 2014 with the integration of 20 formally separate New South Wales tribunals, including the Consumer Trade and Tenancy Tribunal. Now, if you are wanting to make an application to NCAT, the application forms are available from the NCAT registry. There is an NCAT registry in Newcastle, and the details are available on NCAT's website. A fair trading centre, your local tenants advice and advocacy service. They are also available on NCAT's website. The application form includes advice on how to fill it in. If you are after an urgent hearing, you can attach a letter saying why your application is urgent. Now, there are time limits in terms of making an application to NCAT. Now, an application about a breach must be made within 3 months of becoming aware of the breach. Other types of applications have different time limits, and they are set out on the application form. If a time limit has passed, don't despair too much. You can make an application for an extension of the time limit in which to make the application. Now, there are some costs involved in making an NCAT application. It costs $51, or if you are in receipt of a Centrelink income or you have a seniors card, the cost is $13. But you need to provide evidence of that at the time the application is made. In very special circumstances, fees may be waived or postponed. So if you have any questions about whether or not you're eligible to have a fee waived, you should discuss that directly with the NCAT registry. If you need to summons a witness or summons documents, so you want someone to produce a document, that involves a separate cost, and that's also $47. You should definitely get some legal advice about summoning a witness or documents prior to actually making that application. If NCAT thinks that your application is not serious or that you are deliberately wasting its time, you may actually have to pay the landlord's costs. So if you have any questions in relation to whether or not you should actually make an application, you should get some legal advice. Now, in NCAT, tenants will usually represent themselves. You can ask the tribunal to let another person, such as a tenant's advocate, speak for you, but you will need to convince the tribunal member that you need this. It is possible to bring a friend or family member for support. A landlord may use a real estate agent to represent them. Solicitors may only represent landlords or tenants with the permission of the tribunal. So it's not like with court where you go and speak to a solicitor and then they're able to represent you at court. With the tribunal, you need to have the consent of the tribunal to have a solicitor represent you. If you need an interpreter, you should write this in your application or tell NCAT when you get notice of the hearing. And NCAT will provide an interpreter free of charge. It is very important if you have made the application or if you have been served with a copy of the application that you attend the hearing at NCAT, because NCAT can make orders that affect you even if you're not there. If you don't attend the hearing, you could later find out that you've been evicted, that you've been ordered to pay charges that you didn't even know about, or everything that the landlord has said was taken as fact because you weren't there to give evidence that the landlord was behaving unreasonably or making false claims. And if you apply for a hearing and you don't attend, NCAT may dismiss your application altogether. Okay. COVID-19, I did hear on the radio that it has been about 1 year since New South Wales was shut down, and it certainly has been a very different 12 months. So in response to the impact of COVID-19, the New South Wales government introduced new measures to restrict when landlords can evict tenants due to rental arrears as a result of COVID-19. These restrictions were originally due to end on the 15th of October 2020, and they've now been extended until the 26th of March 2021. So at this stage, there's about another 9 days of these measures. So the measures include a restriction on landlords evicting tenants who have been financially disadvantaged by COVID-19, unless they have first attempted to negotiate a rent reduction with the tenant. Extended notice periods for certain other lease termination reasons, allowing tenants financially disadvantaged by COVID-19 to terminate tenancy agreements where the landlord will not negotiate or where it is necessary to avoid financial hardship, and retaining the ability of landlords to terminate a tenancy agreement in cases of undue hardship. Under the measures, landlords must attempt to negotiate a rent reduction with an impacted tenant in good faith before seeking to terminate a tenancy. And you can only give a termination notice or apply for a termination order if it is fair and reasonable to do so in the circumstances. Fair trading offers a tenancy moratorium dispute resolution service that can assist landlords and tenants to try and reach an agreement. Landlords can still apply to the tribunal at any time to take possession of a property if they themselves are suffering undue hardship. All tenants not impacted by COVID-19 are expected to continue paying all rent and charges in full. Now, tenant databases and blacklists. During the moratorium period, so from the 15th of April, it was 2020, to the 26th of March this year, 2021, there is a prohibition on listing a tenant on a tenancy database, so blacklisting essentially, if the proposed listing is for rent arrears that are as a result of being financially impacted by coronavirus. Although you can't be blacklisted for an arrears debt during this time, you should continue to pay as much rent as you can afford. The landlord will still likely be seeking to recover any unpaid rent at the end of your tenancy. When your tenancies end, you should try and come to an agreement about the amount that you'll repay and the time frame in which to repay the debt, so including the amount and the dates when that is payable. It's important that if you reach an agreement along these lines, that you put it in writing. Take into account that your bond is still held with the rental with fair trading, and complete the outgoing condition report with the landlord or the agent, and come to an agreement about the release of the bond. This could go some way to reduce the arrears debt owed. If you're not an impacted tenant, then you are not covered by these protections. And if you are evicted, owing more than what your bond is worth, or by a tribunal order, you may still be listed on a tenant database for up to 3 years. And this can have a serious impact on your ability to find a home in the future. However, you may still be able to apply to NCAT to have the listing removed if you can demonstrate it is unjust in the circumstances. Now, if you're looking at ending your tenancy outside of a fixed term agreement, if you're in a periodic agreement, so your tenancy is ongoing, you can end your tenancy by giving a minimum of 21 days notice and leaving by the vacate date in your notice. It is worth getting in touch with the landlord or the agent to explain your current financial circumstances or your health circumstances. And you may be able to negotiate and agree on a shorter period of notice. If you do come to an agreement with the landlord, make sure you have this confirmed in writing. It's one thing to have a discussion with the landlord or the agent and for them to say something or agree to a proposal, but it never gets put in writing. So it's impossible to prove then that they've ever agreed to it. So that's why you should always make sure to get that in writing. Now, it's important to note that a landlord is not required to consider this request, but it's definitely worth a try. If you have a fixed term agreement, so the fixed term period of your tenancy agreement has not yet expired, you may have to pay a break fee or compensation to the landlord for breaking the tenancy agreement earlier. As mentioned previously, it is worth writing to the landlord to let them know that you are wanting to break the lease early and asking them to consider waiving any applicable break fees or compensation claim. If you have somewhere else you can stay, weigh up waiting for a response from the landlord or a possible application to NCAT against any notice or penalties that might apply. Make sure to ask the landlord to respond within a reasonably short time frame, as waiting for weeks to get a response or determination could end up costing you just the same amount as paying the break fee. If you have an older agreement, you might find it useful to refer the agent or the landlord to the newly introduced structure for break freeze that applies to tenancy agreements entered into after the 23rd of March 2020. Okay, now at the moment, where rent reduction negotiations have failed, COVID-19 impacted tenants are able to end their fixed term tenancy early with a reduced penalty. You can apply to NCAT to end your tenancy early, where you have requested the landlord engage in formal rent reduction negotiations and they fail to respond within 7 days or refuse to participate. The landlord doesn't respond to a notice from Fair Trading to engage in a formal rent reduction negotiation process within 7 days, or fails to stop participating in the formal process. And good faith negotiations fail because the rent reduction that the landlord can agree to are not affordable for you, because the financial hardship that you are facing due to arrears that may have already accumulated and any other further financial hardship you are likely to face due to arrears you have already accumulated and or any further arrears you are likely to accrue if the tenancy has not ended. In this situation, you can only be required to pay up to a maximum of 2 weeks' rent in compensation, and the tribunal or NCAT has a discretion not to impose any fee at all. Now, NCAT has temporarily adjusted its practices and procedures in response to COVID-19, and currently all stages of hearings are being conducted over the telephone, audio visual link, or on the papers. And that is still current as at the moment. Any other further changes to NCAT's services will be announced on NCAT's website. Okay, where to get help? So if you are located in Newcastle, you can contact our service, the Hunter Community Legal Centre, or you can also contact the Hunter Tenants Advice and Advocacy Services. If you are located down the coast, the Central Coast Community Legal Centre is able to give legal advice, and there is also a Central Coast Tenancy Advice and Advocacy Service who could also give assistance. And depending on if you're located on Port Macquarie or in Sydney, there are other specialist centres that are able to give legal advice. Now, there are statewide services. The Tenants Union New South Wales is a statewide service that is able to provide assistance. And then, of course, there is also Fair Trading, NCAT, the Anti-Discrimination Board, and the Human Rights Commission. Now, questions. So there are a couple of questions in relation to, well, there's one in relation to repairs. Now, the question is, who will pay the repair money, the tenant or the landlord? If a tenant or their guest has damaged the property, then the tenant would be responsible to pay for that repair. If there has been a situation where the stove has broken or the hot water service has, failed, and you're not able to contact the landlord, then a tenant can pay that money for an urgent repair and then recover up to $1,000 from the landlord for the cost of those urgent repairs. I hope that answers that question. If not, please let me know. Another question is, could you please explain the difference between property damage and repair of property? I'm not quite sure what you mean by that question, so if you wouldn't mind just perhaps popping into the chat and just explaining in a bit more detail what you mean. And the last question that is writing. Is email communication deemed as writing? Yes. If there is any requirement to give notice, then yes, you can do that via email. All right. Well, it sounds like there aren't any other questions. So I'd like to thank everyone for attending the community legal education today, and I hope that you've been able to take some things away in relation to rental rights. We are having a number of other online community legal education over the next coming weeks, so you should check out the schedule on the UNSA website. All right, and I think I'll end it there unless there are any other last minute questions. All right, thank you, everyone.